expect from the Commission, particularly about being called creeps, about overdoing it and about bossing people around. So it's interesting to hear that other people are called by the same names as we are. In very general terms, we have done some analysis over time as well of this gold plating, double banking and so on. And it was reassuring to us that a similar experience was had in the UK in that the substance slipped away, because we've had a lot of dialogue with people about gold plating and so on. It can be quite a complex issue to examine, because much community harmonisation is minimum requirements, and in some areas, such as environmental protection, of course, the treaty actually provides that member states can legitimately and justifiably go further, and that is part of the political process of bringing member states together on a minimum standard, but not stopping member states that want to go further from going further. So, as Lord Davidson said, a political judgment has to be made. We may be hitting our operators harder, but there may be justifiable reasons in certain areas to do that. We may want higher standards for the protection of animals in transport than other member states, etc., in different areas. The more, of course, we're delighted whenever there's that kind of convergence of results in examining these issues, but it doesn't release us from the obligation of continuing to examine where we are. I'm not sure if earlier sessions in the conference have dealt with it, but I'm sure you're all fully aware of the major work which is being done now between the Commission and all the member states, examining a wide range of areas of existing regulation at EU level and at national level, and looking at the justification for the different requirements which are applied either as a direct result of the EU measure or added at national level, and consulting on whether business really accepts that or citizens want that, with an open mind to reviewing and reducing that legislation. That is, as you can imagine, a huge exercise, because in the areas which have been selected, it's not just the matters covered by a particular EU directive or regulation. It is all the regulation in that area, including tax and other questions. So it is quite a considerable task. But briefly, I would just like to run through the main work that we're doing at the moment to implement our September 2007 communication on a Europe of results applying EU law. The first thing is that we want to prioritise more upfront preventing, identifying excessive problems of implementation, excessive cost of regulation, and preventing problems occurring in the development of EU regulation. So, I mean, I think you're aware that there's a general programme to revise the impact assessment process, and that will result in stronger requirements for a verification of the costs and methods of implementation required in order to improve that aspect, and where it's too heavy to avoid issues of regulation which would not be practical to apply. We're also concentrating much more on the choice of instrument being used. There are many areas in which directives have been used up till now, although member states have not been left with a wide range of choice as to how to transpose them, because they go into a lot of technical detail on the chemical compounds of pharmaceutical products or whatever, and that can involve costly government as well as cost to business, in the sense of quite often frequent requirements for technical updating as science develops and technology develops, and every time the Commission adopts an implementing directive, 27 member states have to go through the process of transposing. It is a daunting process, because of course we have 27 member states, we have more than 70 regional authorities with some degree of legislative competence, and it can take as many as 100 transposition measures in one member state correctly to transpose a directive, and nearly 350, very occasionally, that's the most, to transpose a directive completely in all member states. So we need to find ways where transposition of directives is not strictly necessary to save government the costs of that, where in effect member states will just be reproducing the terms of the directive. And this is already being done in some areas. I mean, in motor vehicles, you will never see on the road a rear view mirror on a car which isn't to the exact specified measurements in what is now the regulation but was the directive. We're also looking then and prioritizing how hard we focus on the implementation. Directives normally require about 18 months of transposition. Regulations require some implementing measures. We need to distinguish between different kinds of measures and how easily they are implemented. Something like the recent directive on services requires a huge amount of institutional network creation and building of structures and systems for the exchange of information to make it operational, whereas a small directive updating some technical requirements in an existing directive in a very solid, well-established area doesn't need so much follow-up to its adoption. And we want to organize with the member states what we agree during the legislative process is the most proportionate and appropriate follow-up techniques, expert meetings, guidelines, creating the bodies which are necessary to apply the law, so that we agree what is the most effective way to ensure that there will be fewer problems once the regulations are in force. And we will be setting up networks of contacts for the implementation of regulation across the board, so that there is never apart from the expert committee meetings which we organize, there is never a member state or a moment in the transposition implementation process when a question cannot be sent and answered on a particular point at the appropriate time that's useful for that particular authority. We're developing a standard form of correlation table as well to help member states working on providing these tables which express the link between the individual provisions of a directive and the various measures adopted in the member state to transpose them. And that is not only for our use, but for citizens, business to understand where the relevant provisions are, for courts and tribunals to be able to interpret the provisions in the light of their relationship, and for the better administration of the law by member state authorities as well.